Hello and welcome to another video by AIA Contract Documents. In this video, we're going to be talking about notice requirements in the A201-2017. That's the general conditions of the contract for construction. My name is Mike Koger and I'm joined by my colleague Jimmy Germano. We're both staff attorneys for the American Institute of Architects in Washington, D.C., and we work in the Contract Documents Department. As always, we can't give legal advice on this video, and nothing that you hear in this video is a substitute for consulting with an attorney who is licensed in your jurisdiction who can talk with you about the specific issues that you are facing. And with that, Jimmy, I'll turn it over to you.
Sure. Thanks, Mike. So like you said, today we're going to be talking about the A201 notice provision. I'm going to break it down in a little bit of detail here. So the notice provision is found entirely in section 1.6. As you can see on your screen in front of you, section 1.6 is the notice provision that sets forth how and to whom notice is to be given by the parties to the contract if they are required to give notice. So it's broken down into two sections. It's 161 and 162. And I'm going to refer to 161 here as the sort of regular notice provision. So it's not notices of claims, which are going to be in 1.6.2. So if the parties just have to give regular notice of something that's not a claim, they want to look to 1.6.1. And it might be a little helpful to talk about maybe an example of what a regular notice might be. So in another one of our videos, for example, we talk about the fact that the contractor has the right to request financial information from the project owner. And if the project owner provides financial information to the contractor, then the owner is precluded from changing its financial arrangement without giving notice to the contractor. So that would be an example of some type of regular notice that would fall within the context of 1.6.1. So section 1.6.1, as you can see on the screen here, if you're going to give regular notice, notice shall be provided in writing, and it has to be delivered in person, by mail, by courier, or by electronic transmission if a method for electronic transmission is set forth in the agreement. So, for example, electronic transmission, of course, it's becoming more common on construction projects and particularly if the parties are utilizing BIM, for example. So the parties might choose in their BIM protocols, for example, that they're going to allow for regular notice, they're going to allow things like emails or maybe just uploading a document or a type of notice to the document retention system that they have set forth in their BIM protocols. I should also note here that, as with pretty much every clause in the A201, the parties are free to modify this provision or their BIM protocols if they want to allow for other types of delivery, particularly for regular notice and then again for notice of claims, as we'll talk about next. So speaking of notice of claims is set forth in 1.6.2. So let's switch and talk about claims. So if the parties have to provide notice of claims, first they should understand what a claim is. And a claim is defined in section 15.1.1. It's defined as a demand or assertion by one of the parties seeking, as a matter of right, payment of money, a change in the contract time, or other relief with respect to the terms of the contract. And the term claim also includes other disputes and matters in question between the owner and the contractor arising out of or relating to the contract. So if the parties are providing that type of notice, if they're providing notice of a claim, then they want to look to 1.6.2, which requires that the notice shall be provided in writing and has to be delivered by certified or registered mail or by courier providing proof of delivery. So they need to adhere to section 1.6.2 and those specific types of delivery methods if they're providing notice of a claim versus, like we talked about in 1.6.1, just regular notice. Should also note here that 1.6.2 references section 15.1.3, and that's the notice of claims provision that's obviously farther down in the A201. And that just sets forth the time within which a notice of claim shall be given and some other specific nuances with respect to notice of claims. But today we're specifically just talking about the notice provision in 1.6. With that, I think we have maybe time for one quick question. Mike, anything on your mind with respect to the notice provision?
Yeah, so I'm wondering if you could talk a little bit about why the notice for claims are handled differently than notice of other items, and particularly why are electronic transmissions not allowed for a notice for claims?
Sure. So I think that's a great question. It's something that I think a lot of people wonder about why the notice provision is set up this way. And the reason why is because a claim is a big deal. A claim triggers a lot of other things and a lot of other requirements and deadlines and actions on behalf of both parties, both the party giving the notice and the party receiving the notice. So to give an example, if you're a project representative for an owner, you might receive 100 or 200 or 300 emails or text messages or in-person conversations every day about a particular project. You might be walking the project site, etc. And the notice of claims is set up to exclude, at least as drafted in the standard form, to exclude email or electronic delivery because a claim shouldn't be mixed in with all of the other conversations going on about a project. So if you're receiving information from a contractor or an architect or a CM about a project, you might get an email about the type of molding that's going in a certain room, or then an issue that you might be having with the scaffolding delivery, and then you might be talking about tile color, and then slipped in there as another email, it might say just see attached, and then the attachment, lo and behold, is a $40 million delay claim or something like that. So it's set up that way to make sure that those types of claims are noticed to no pun intended, by the owner upon receipt. And it's also, if you notice, it separates out in-person delivery as well. And that's so that if you're having a project meeting, even though it does need to be in writing, if you're doing it by certified or registered mail or courier providing proof of delivery, there is a date and time stamp on those types of delivery methods. So some third-party entity, either the post office or the courier, can go back and verify exactly when that document was delivered, versus in person there might be a little bit of a dispute as to when exactly it was delivered. And with the specific time frames that come into play, you definitely want to go back and know exactly when notice was required to know if you were timely or not. So that's why that distinction's there.
Sounds like it's probably a good thing that multi-million-dollar claims won't end up in your junk email file.
Yeah, that's the point. So with that, we'll just say that if you do want to learn more about the AIA contracts, you can visit our webpage, aiacontracts.org/learn. If you have questions about the document content that we offer or the online services, the contact information for further support on those is up on your screen. And thank you very much.